Okay, hello and welcome everybody. My name is María. I'm the head of the Law and Language Department at Austral University. We are in charge of the legal English courses at the postgraduate level. And today I have the pleasure to introduce Consuelo Conti, who is not only the speaker for this talk, but for this masterclass, but also the director of two of the programs that we have in legal English. One is the program on which is called Practical and Intensive Course in Legal English, and the contract drafting workshop, which is both of them are taught twice a year. So I would like to say a few words about Consuelo, and then I will give you just a rough idea of how we are going to lead this masterclass today and how you can interact with the speaker. María Consuelo Conti Toutin has a Bachelor of Laws from the University of Buenos Aires School of Law in 1993, and an LLM from King's College London in 2001, and a postgraduate degree in the regulation of financial markets from the London School of Economics in 2001. Consuelo is an Argentine lawyer specializing in international commercial law with more than 25 years of experience in the United States, Brazil, the United Kingdom, and Venezuela. She is also a university professor with more than 20 years of teaching experience, both at the undergraduate and graduate levels. She's currently the director of the postgraduate practical and intensive course in legal English and the contract drafting workshop at Austral University. And she's also the academic coordinator and a professor of the postgraduate diploma in hydrocarbons law, organized between Austral University and the University of Salamanca, Spain. At the undergraduate level, she teaches common law institutions at Austral and other classes in institutions such as the University of Buenos Aires, at the School of Law and the School of Economic Sciences, Torcuato Di Tella University, and Universidad del Museo Social Argentino, among others. Consuelo is proficient in several languages, namely English, French, Spanish, Italian, Portuguese, and Turkish. As I was telling you, the way this is going to be is if you have any questions, you can write them in the chat or in the Q&A section of the Zoom. And we will read all the questions at the end of the presentation, and Consuelo will answer them at the end. In the meantime, Consuelo may ask you to answer some questions, and you can do that in the chat freely. So Consuelo, thank you very much for being here today, and the floor is fully yours.
Excellent, Mariano. Well, good afternoon, everyone. It is a pleasure for me to have these masterclasses, as I think that this is the best way actually to pay forward and to share knowledge and a little bit of where linguistics are going with these changes that we are experiencing, both in the legal profession and in general in business transactions. So I want to thank Mariano and Austral University for giving me the opportunity of sharing all this with you. And without further ado, I'm going to share my screen and start with my presentation. So we're going to talk about legal drafting and the skills you need, but particularly what are the challenges that we face as both lawyers and translators, because when we are giving legal advice in a language that it's not our own, we face a challenge as translators, and we function as translators. And many times we lawyers have to translate legalese or legal jargon or legal technical terms to our clients who maybe are not versed in the law. It's not the same thing if I'm talking to a US or UK attorney than if I'm talking to a German or Japanese businessman. It is important to know who is the recipient of our message. And we are going to talk about that in a minute. And the idea that I want to convey in this lecture is the challenge that we are facing, the challenge that we are facing now, that we are faced with globalization, this post-pandemic situation. And many of you are maybe from not only from Argentina, but from Latin America or other countries, and maybe working abroad and actually exporting services to someplace else. Remote work is something that is here to stay. So a lot of the tools that I'm going to share with you will be very useful for all of those who actually work remotely with different countries other than your own. So welcome everyone again. Thank you very much for this opportunity, and for me it's a real pleasure. We are going to address two main questions. One is, why can't I understand what I read? And this is a question that not only is very applicable when I'm reading in a language that's not my own, but it even happens it even happens to me when I'm reading in my mother tongue. And I am proficient in several languages, and I can understand the words, but I cannot understand the message. And why is that? Why is that I don't understand what I read? And here we see a meme that I find very funny. I go and I read a whole paragraph very quickly, and then I have to go back and read it again because I realize I didn't understand anything. So there are a lot of causes to this. We find incomprehensible texts that are not easy to understand in a first reading. One of the main and most important difficulties. Complicated structures that actually are complicated without any purpose. Grammar and syntax mistakes. How awful it is to find a piece that's filled with mistakes that are actually easily erased by a spell check. Ambiguity, polysemy, when one word has several meanings. And in English, as a difference to Spanish, we have less words, and each word has many different meanings. And we have words that have many meanings or different meanings, several meanings in legal English. A very common example of polysemy is, for example, get. To get something is to fetch something, but to get something, it's also to understand it. But in legal English, I have, for example, security. Security is, of course, general meaning, the sense of being safe, but it is also a collateral, okay? Something that's been given as a guarantee. But security is also a title or bond or a note, okay? A title representative of debt. So many different meanings for one single word. And how can I get that meaning? Through context. When the context does not help the reader understand the meaning of that word, the message gets lost. Big hurdle there. Inverted structures. How how common is to find passive voice and how fond are lawyers of using passive voice. Why? Because we don't want to stick to the correct structure of subject, verb, object, and we don't want really to say who is performing the action, because everything has to be anonymous. And inverted structure and passive voice brings along a lot of difficulties in understanding the message. Nominalizations, all those words ending with shon, with sion, instead of saying, I informed the people of the situation, then the people were informed of the situation, or the situation was informed, and we don't know who actually informed. So the author gets lost in the passive voice and the inverted structure. Multiple negatives, and we're going to talk about this in a moment. So common in colloquial English when we say we don't need no education, or I can get no, I can't get no satisfaction. I cannot get a single meaning out of this context, because actually what I get is a hurdle of negatives. If I find a sentence saying the following events are excluded from the prohibition, isn't it better to say the following events are permitted? Why should I have multiple negatives? And remember that in English, as in Spanish, not in all languages, Polish is an exception, two negatives actually form a positive, like the example I just gave you. So when you sum up too many negatives, you may actually be conveying a different meaning than what you really want to say. So careful with that. So, summing up, difficulties I have as a reader. Text is not visually appealing. I have a chunk of words and no vertical paragraphing, no formatting. It's just no air between those paragraphs. And believe me when I say that we lawyers, we don't have avid readers on the other side. No one is keen and eager to read a legal text or a legal memo. Oh, it's from the lawyer. So actually, the text that's not correctly designed and formatted, actually, it's more difficult to understand. It's filled with legalese, with these technical legal words that many people do not know. So again, your message has to be custom made, tailor made, or as we say now, bespoke for exactly the person you're addressing to, for your recipient. And the result of all this is that the recipient does not understand the message the first time they read it. And that is the main problem. Because actually, the main objective as a writer should be, the objective is to actually get your reader to understand your message the first time they read it. Why do readers don't understand what I write? So we saw the problems that we face as readers, and now let's see the problems that we face as writers, which is pretty much similar. But I cannot convey my message. I find it difficult to convey my message. Or very applicable to lawyers. And this is the reason why lawyers use a lot of passive voice and a lot of inverted structure. I don't want to give all the information. I don't want to say Peter stole the car. I want to say the car was stolen, or I want to say the car was allegedly stolen. I start writing as soon as I get my pen and paper, or I sit down before my computer and off I go. No plan, no structure, no design, no pattern whatsoever. I go with the flow. The result will follow. Now, to have a good piece of writing, I have to start with a plan. Professional writing says a lot about who we are as profession. It requires legal knowledge. It requires knowledge of the language we are writing. It's legally accurate, has the appropriate register. Whether it's an email to a client we know, then we can have an informal register. But then we have to use a formal register if we are writing a legal opinion, for example. It's adapted for the reader, it's bespoke for the reader, complies with grammar rules, and syntax is comprehended within grammar. Complies with the 3 C's. It's clear, it's concise, it's cohesive. And I add 2 more, correct and careful, and coherent as well. So when we write, we have to have 3 main blocks of attention: simplicity, brevity, and organization. And the 3 are equally important. Simplicity. The reader should understand the text after reading it for the first time. And how do I achieve simplicity? By choosing simple words, common everyday words. We will talk about plain legal English later. By choosing simple structure, short sentences. Brevity, short. If I am writing an email, don't go beyond 1 screen. People don't read. People don't like reading legal stuff. So don't actually hand them a 300 pages memo. Feed them the important information first and try to be as succinct as possible. If you need to have further information, look for an attachment, okay? So try to express all your reasoning in short, simple sentences. And then we will see this later on, how we can connect those sentences. And even the most complex reasoning can be summed up in what we will call a legal syllogism, and I'm going to refer to that later. Organization. You have to have a plan. You have to have a structure, and I'm going to give you one. But that structure and that design has to be a design that allows that particular reader to understand the message and to find the important information right away. Two very brief quotes that I really enjoy. One is brevity is the soul of wit, that are great words mentioned by Polonius in Act 2, Scene 2 of Hamlet. And it is so difficult to be short. And believe me, I struggle with that daily. And really, really intelligent people are able to actually extract the important information and deliver it appropriately. And actually, we can achieve brevity with work. So sometimes you see a short piece and you may think with an old mind, not with nowadays thinking. You may think, oh, he wrote this in 5 minutes, but you read it and you understand everything and you get the message. And no, that wasn't written in 5 minutes. That has a lot of thought into it. So brevity is the soul of wit. And then we have the Dowager Countess of Downton. The great actress Maggie Smith delivered these words. Sarcasm is the lowest form of wit. And so true. And one thing that I want to address is never, ever tease or outwit or outsmart your colleagues or your clients or even a judge or a member of the justice or a member of the court. Why? Maybe they are in the wrong. Maybe you are right, but don't go beyond. One thing that is important that we have to always remain true is to respect and to politeness when drafting professional legal writings. And one thing that I always appeal to is humor, and that's great. And you can have a joke, but you don't have to cross that line. So always be polite, always be respectful. And when writing in the professional milieu, then formality is a must. How can I make my text readable? Well, put yourselves in the shoes of the reader. And the truth is, we don't read. And this is scientifically proven, by the way. We scan. Actually, we do like this. 1, 2, 3, 4, 5. We go from upwards to downwards, from left to right. So we have to design our written pieces in a way that they are friendly to the reader, that we have paragraphs, that we have air, that actually it's easy to scan the important information. Let's talk about inclusive language. Actually, inclusive language in English is easier than Spanish because it has very few gender markers. One thing that maybe you realized from my early chat is that I used the singular they. I avoid the he, she. And before, when I started, Mariano told you that I studied in London, and when I was living in England, very many years ago, dinosaurs were alive. I had actually a teacher at Marion Westfield College, now at St. Mary's, that even changed names. So you know how many years ago I'm talking about, told us that for companies, we have to use the pronoun she. Now, we don't use the he or the she, we use the it, and generally try to use the they, okay? The singular they is the way to go to avoid gender. Really, English doesn't pose much of a challenge with the nouns, as generally we do have gender neutral forms such as teacher. Or present, and it's pretty friendly, but we do have, it's not like Turkish, for example. The doesn't is a totally gender neutral language, but it has some exceptions. For example, when we say waiter or waitress, try to find a neutral equivalent such as server. Okay, or back again, when I studied back in those days, we used to say policeman, businessman, spokesman, chairman. Well, it has been some years now that we try to use business person, spokesperson, police officer. So try to find a gender friendly equivalent or gender neutral equivalent. And when referring or addressing people, well, then the typical pronouns, and you will see that many times with the signature in letters, in emails, a person may give you that information and would say, well, she, her, or I would like to be addressed as Mr. or he, or Miss or Mrs. or she. If you don't have that information, well, then a good alternative is MX, which is totally neutral, okay? Instead of the Messieurs or the Mr. or the Mrs., okay, or the Miss. So if you don't have that information, then you can have the MX, which is gender neutral. Let's talk about plain English in legal drafting. And why is it important? And this quote from Robert Waddle really sums up what I've been saying so far. That is this this may be objective sometimes that's searched by lawyers of actually being anonymous and hiding behind the jargon and the inverted structures. And Robert says, in jargon, nobody ever does anything. You don't know who the author is. Nobody feels anything or causes anything. Nobody has an opinion. Opinions are had. Okay, subject, verb, object. No, the structure is inverted, and I have first object, then verb, no subject. Opinions are had. Causes result in. Factors affect. Everything is reduced to vague abstraction. The writer can even abolish himself. Itself would be there, but I'm respecting the quote. For jargon never sounds as though anybody has written it. It seems simply to come about as from a machine, and it talks mechanically of things that come about through some indistinct interaction of forces. No one takes responsibility. No one is the author of anything. Everything gets lost in this mumbo jumbo of words without any personality, without any responsibility. What's the problem about that? The problem is that the message gets lost in that mumbo jumbo. And first, it doesn't reach the recipient, or worse, maybe the recipient gets a wrong message. So plain English, that's also known as layman terms, enables the reader to understand a message the first time actually the recipient hears or reads the message. And it is perfectly fine to use plain English in legal drafting. And plain English uses common everyday words, shorter sentences, simpler constructions, and actually reduces plain legal English, reduces the use of legalese or technical legal jargon only to specific cases for specific recipients, okay? So as a rule, when in doubt, try not to use legalese if you feel that your recipient may not understand the message. Again, one thing is to write pleading that will be read by the court, and another thing is to write a memo that will be read by a Japanese client who is not a lawyer, okay? So the US Legal Writing Institute has its own opinion on legal writing. That is that actually people were complaining that they didn't understand lawyers' language. Actually, I had that experience myself. I had clients with a sentence, with actually a judicial decision. We don't say sentence in English. We also always say judicial resolution or judicial decision, with a decision of the court saying, could you please explain this to me? Have I won or have I lost? Because I'm reading and I don't understand. So the objective is to be precise, to get the message through. And actually, it is better achieved by using simpler words, which may be more accurate than with complex words that sometimes not even the writer knows the meaning of. And one thing that I think that we've achieved with the passing of time and the years is that nowadays, when we find good legal draft, we are not looking for big pompous words. When I started working, there was this belief, this traditional belief, that I have to use complex words in English to show off. No one actually is looking and actually no one wants to be impressed. The client wants the result, the court wants the information, the reader wants the information. So it's not about showing off, it's about putting the message through. And the main enemy is confusion, and legalese many times contributes to confusion. The US has the Plain Writing Act of 2010 that actually requires federal agencies to communicate their resolutions in plain English and to use plain English, both in the drafting of statutes and regulations, and also when drafting any kind of communication. The idea is to have readable languages, and this is followed, this same criteria is followed by several states. In Argentina, and particularly in the city of Buenos Aires, the city of Buenos Aires has recently published Manual de Lenguaje Claro. If you haven't read it, I warmly encourage you to do so, because it is really very well put together, and I think that's a good a source for guidance when drafting in Spanish in that case. But many countries do have so, and many states in the United States as well, and in the UK as well. So the idea of using plain English is to actually achieve the objective is that the reader finds what they need easily, understands what they find, and uses that information correctly. And that is what the Plain Language Federation calls correct communication in plain language. A communication that has a wording, a structure, and a design that actually enables the reader to easily find the information, to understand that information, and to use that information. Why should we use plain English in legal drafts? And Brian Garner says that the phrase plain English shouldn't connote drab and dreary, language. Actually, plain English is interesting to read. You don't have to inform. You have to tell. How different these two words are. One thing is I'm informing, and different thing is I'm telling you a story. And the story sticks to your head. Actually, plain English can be much engaging if I know how to use the correct words. I can choose far more interesting words, and actually I can use words that my reader will understand as opposed to legalese. And I will find a lot of replacements for words that may sound very fancy, but actually are so obnoxious that maybe my reader does not understand them, or worse, misunderstands them. Okay? Let's take a look some examples of these excessive characterizations. And believe me, I see these every day. Please note that. Just go straight to it. It is of the utmost importance for the avoidance of doubt. Why clarifying something that you have actually to state clear from the start? It should be noted that as a result of the foregoing, just you have connectors consequently, for example, it should be taken into consideration that I would like to take this opportunity to mumbo jumbo, excess of words that don't add to anything. And let's think a little bit. Can we replace those phrases for one single word? Instead of saying for a period of a year, for a year. By means of, by. On a monthly basis, on a quarterly basis, monthly, every 3 months. Concerning the matter of, about, or on. We have prepositions, and in English, we have more than 100. So you do have a lot of words to choose from, believe me. Taking into consideration, considering, in order to. Latin lawyers have a love affair with in order to. And when you read in order to, every 3 or 4 sentences, actually, my head aches. So in order to, forget it. I know it's easy to say, it's difficult to just release, but release in order to, just to will do. During the course of, in the event that, if, simpler, more effective, has more punch to it, for the reason that, because, until such time as, until. Be short. Actually, you will win by having the attention of your reader. You lose the attention of your reader with so many confusing words. Less is more. Take a look at this example. On and about May the 12th, 2020, Mr. Edward Jones, and we are going to talk about the hereinafter, here and below, here and around the corner in a minute. The client, by means of an offer letter, hereinafter, the offer letter, enter into a certain agreement. We love to say a certain agreement, entitled the teaching agreement with Mrs. Consuelo Conti Toutin, hereby Conti Toutin, whereby Conti Toutin agreed to help the client to design and create a legal English teaching guide. Please note that Conti Toutin's efforts in connection with the teaching agreement and the word product produced by Conti Toutin related to said agreement shall be referred to hereinafter as the work. What do you think about these? How many lines? 1, 2, 3, 4, 5, 6, 7, 8, 9. See? On May the 12th, 2020, Edward Jones and MC Conti then entered the teaching agreement, or entered into the teaching agreement, where Conti then will help design a teaching guide, the work. 3 lines. No need to say hereinafter with the inverted commas and the parentheses. That's fine. The brackets are fine. Try to reduce your word count, okay? And start a plain English diet, okay? Let's get into general considerations for drafting. Do not translate. To all fellow translators, traduttore, traditore, we are actually committing treason when we are translating. Sometimes there is no exact matching word nor a kindred concept in English, and maybe we can confuse a reader. So just explain. If we want to say, for example, periodo de sospecha, and we are sending a memo, for example, to the US, where hardening period is not a word or a term that might be understood, please don't use any other words. Don't use cram down, which is actually different than cram down in Argentina. And you have cram up and cram down and chapter 11, and you will create a mess in the head of your recipient. Just explain. Say it's a period of 2 years counted backwards as of the date of insolvency. Explain the concept with simple, common, everyday words. Bear in mind, who are you writing for? The nationality of the recipient, whether that recipient is versed or not in the law. And always, always prefer plain English to legal English, and never ever say or write something you don't understand, and do not create or invent words. Let's talk about wording, design, and structure, and then I will go back to the words that I have a couple of things to add to that. Write short sentences, organize your information, divide your ideas in paragraphs, use vertical formatting, give air to your drafts, use bullets, use numbering, use indexes. You know that all word processors, Word, MS Word has actually a function where I can have an index and I can click on article 1 and it takes me directly, for example, article 89, and it takes to article 89. So have a structure. Even the most complex contract can be structured correctly. Use visual resources. Add visual resources to your draft. Use diagrams, use tables, use icons, use different colors, use highlights, okay? Bold letters, italics, okay? A well-written draft is the one that gets read. One thing that's important when we are talking about fonts, and I don't know if I have this further on, but I try not to use the underline so that it's not confused with a link. And when you use fonts, use Arial or Calibri that are sans serif fonts, that they don't have, you know, all the, for example, Times New Roman, that's a serif font. It is easier and more actually easy on the eye. It's easier to read the sans serif fonts. So let's go to the 3 C's: clear, concise, and consistent, cohesive, okay, and correct and careful. A good draft, and I'm talking about any kind of draft, whether it's a pleading, whether it's a mail or a memo, it should flow from start to finish, okay? It has to have actually a common and a flowing idea. And then we will talk about a little bit more about how to structure this. Define all the terms and try not to create confusion. If I have, for example, a term that can lead to confusion, typical terms would be affiliate, for example, subsidiary, another one, controlled company, whether there is control in a certain country or in the same country. Maybe I have different regulations that establish different percentages of stock ownership to establish control. So for that specific draft or for that specific contract, controlled company will mean this. Okay, so define, and note that your definition should be marked and identified in a way, let's say capital letter at the beginning or bold, however you want to use what we call conspicuous language, because it's conspicuous to the reader. It draws the attention to the reader. All capital letters is it's not so common. It is common in the US for waivers, but it is perceived as if you were shouting. So maybe bold or the first capital letter should be more wise recommendations for definitions. But define all those terms that may be or may lead to confusion because may have different interpretations. Also, avoid the passive voice. Modal verbs try to avoid shall. It has different meanings, actually. Brian Garner, the author of the Black Law Dictionary, has 5 different definitions for shall. So try to use must or can, depending how the sentence goes, but actually try to avoid shall as much as you can. Pay attention to grammar and punctuation, and actually use a spell check and keep it formal. Let's talk about false friends. And when I was talking about this confusion, I was thinking about these very funny problems that we come across when we are thinking in one language, but actually writing in another one. And in English, we celebrate good times. We celebrate New Year. We celebrate Christmas. We celebrate a party. We don't celebrate a contract. We never celebrate a contract. We execute a contract, which actually is signing, but we don't celebrate contracts. We don't assist to meetings. We attend a meeting. We assist someone. We help someone. Actually, when we say this is a current thing, when we say something makes sense and you are a sensible person, I'm not saying que sos sensible. I'm saying sos sensato. To make sense tiene sentido en español, no hace sentido. Asignamos, distribuimos gastos, no alocamos gastos. Alocar quiere decir volverse loco en español. Detentar en español quiere decir tener sin derecho. ¿Por qué tenemos que decir detentar y no decimos tienen? Usemos palabras simples. When I say in English, this is the actual contract. Es el real, es el verdadero. It's not the current events. Problemas actuales, current problems. We have to understand the language in order to be able to translate it. So beware of false friends. Let's go back to general considerations. Think in English. You will avoid false friends if you think in English. Try to think in English and not think in Spanish or your mother tongue. Don't cut and paste without reading. Be very careful. I'm not saying don't do it because I think no one is exempt of cut and paste. And actually, I'm not saying draft a prospectus. Okay, sometimes you have to cut and paste, but beware how you do it and be very careful. Use titles, use subtitles, organize your work. Use short sentences, separate your ideas in paragraphs. Use connectors, okay? Connectors of likewise, of contrast, on the contrary, of hierarchy, firstly, secondly, lastly, okay? We have many connectors, use them. If you're going to use terms such as hereof, herein, herein above, herein below, use them correctly. Here is in this same clause or in the same document, therein is in another document or in another clause, okay? Use a spell check, okay? Punctuation, grammar, syntax, important, okay? Beware of modifiers. It's not the same thing to say red pears and apples than to say red pears and red apples. Avoid nominalizations. What's a nominalization? When actually above acts as a noun. Information instead of informed. The information was obtained. No, they gave us the information. And when I say they informed us, I'm obliged to actually mention the subject, and I escape from the passive voice. Avoid multiple negatives, avoid passive voice as much as you can. How to draft legal documents. And we will talk about 4 types of legal writing, and we'll try to speed up a little bit. Objective writing, memos, legal opinions, emails, reports, minutes. Persuasive writing, when I'm not neutral, when I'm trying to convince, for pleadings, okay? The complaint, the answer to the complaint, the counterclaim and the answer to the counterclaim. Why? Because I'm trying to convince someone actually to rule in favor of my client. Motion, briefs, transactional writing, contracts, and regulatory writing, statutes, laws, regulations, bylaws, okay? I was talking about structure. And when I talk about structure, I talk about a plan. And there are many plan patterns, and you can have CREAC and CRAC, but the most common one and the one I teach in my lessons is IRAC, which stands for issue, rule, application, conclusion. And this is a pattern, this is a plan that actually suits any kind of writing. It can be applied to 4 types of writing. And actually, you can have IRAC in each paragraph. How does IRAC work? You first start by laying out the issue. Then you mention the rule or the rules applicable to that issue. Then you apply the rules to the issue. And then finally, you expose the conclusion. The conclusion can go first. That's up to you. But this structure, issue, rule, application, conclusion, will save you a lot of time. Try to have an IRAC structure before you write. Let's take a look at how you can achieve this. First, spot the issues. How can you spot the issues? Take a look at the facts, okay? And lay them down neutrally and orderly, chronologically, and first, the most important ones. The most important information should be placed first. Then the rule. For the rule, use a funnel rule. What's a funnel? Un embudo. Go from the general to the specific to the exceptions and follow the hierarchy. First, the Constitution, then the federal statutes, then the state laws, then the municipal regulations, okay? And if an exception is applicable to your particular case, then you may move the exception to the very first part, okay? All structures may be subject to change according to the case. And explain the whole rule, just don't give a one-liner, okay? Application. After stating the applicable rule or rules, then you have to connect them, okay? And try to keep it as short and as engaging as possible. Keep it visual, okay? And then after your analysis, and maybe you want to devote one paragraph to each aspect of the rule, then you come to your conclusion. The conclusion has to have a sentence that answers the ultimate question of the issue. And that question could be posed as a syllogism. And what's a syllogism? It's a reasoning that works with a major premise, a minor premise, and a conclusion, so that you arrive to the conclusion logically from the reasoning that you've exposed from the issue, from the rule, from the application of the rule to the issue, and your reader naturally falls into the conclusion. Because it has to have a rationale. Your drafting should actually lead the reader to the conclusion. And that conclusion should be round, should take into account everything, all the facts laid out in the issue, all the different aspects of the rule, the application, and then you expose the conclusion. And for example, in case you are drafting a memo, you should take a stand, okay? Be concise, but do not leave anything out, okay? So sometimes brevity and summary leads to missing out. No, don't avoid important information. And how do I achieve this? By planning first. So when I write IRAC in issue, all the aspects of the issue. In rule, all the rules that are applicable. In application, how it falls down. And naturally, I will go to the conclusion. I will draw that conclusion naturally, and my reader will do that as well. If I have a good plan, then believe me, it comes out naturally, okay? And the KISS rule, just keep it simple, sweetie, okay? Objective writing calls for a predictive analysis, while persuasive writing calls for actually an analysis that will lead my reader into my position. I'm a lawyer. I'm not a judge. I'm not in the middle of the balance. Actually, I'm pushing as hard as I can for my side to win. So in persuasive writing, I will actually highlight my strengths or the strengths of my case or the position of my client and try to minimize the weaknesses in my case, okay? So let's talk about how to write a memo, and then we will talk a little bit more about persuasive writing. As I said before, when I talked about IRAC, a memo should have an introduction laying out the issue, question and answer, which would be the syllogism, the facts, the rules, and the analysis, and then the conclusion. Try to have, as I said before, a rules-based reasoning behind your memo. Gather the facts, present those facts in chronological order, and in the most important things, always goes first. The most important information should go first in your writing. Research and outline the rule. Rationalize the rule to fit your case. Define the elements of the rule or the rules. Fill in all the gaps defining the rules. Build your argument using IRAC and write your argument drawing your conclusion out of that argument. Let's talk about emails that is objective writing that we generally as lawyers give a lot of legal assessment. We assess our clients through emails. Emails should be short to the point and with no legal jargon. Let's take a look at this email. Actually, all the examples I'm giving are examples, real examples. This was an email. Of course, I changed some information, but was sent. To my esteemed client, Rob, colon. We don't use colon. In English, it's a comma. We apologize for the delay and a lot of words, thus, until a short time ago. No other information is required. Is it easy to find the information in this email? What do you think? Is it visually attractive? Can you find the key information? There's no paragraphs. There are no paragraphs. There is no separation between the sentences. There's no actually full stop, just stops. There's no air. I receive this mail and really, I don't know what to do. What's the purpose of that mail? Now take a look at this one. Dear Rob, thank you for your patience. Instead of apologizing, instead of saying, we apologize for the delay in getting back to you, then I will show you how to write an email gaining time and sandbagging. Now, I lay the issue. I say what's happening. I say what I need. I say when do I need it. I need the necessary instructions to complete the form before September 15th. And do not hesitate to contact us. Kind regards. If you have questions or queries, doubts are different things in English. Emails should open with a purpose, have one idea per paragraph, and calls with a call to action. What do you want from that person? And an email should always fit one screen. If you have more information, then add it in an attachment. See, if you're late and you cannot really answer right now, well, thank you for following instead of saying I'm sorry. Always try to be positive. Apologies here for the radio silence from my end. You caught me in a particularly hectic time. I'm looking forward to reviewing, but I need more time. I likely need to wait until next week, given my current load. I will touch base with you next Tuesday, April the 4th. So one specific date. Cheers. Okay, informal. Here you have some basic sentences and wordings, formal and informal. Let's talk about persuasive writing. And I could sense that when I started talking about pleadings, you wanted to know more about persuasive writing. So persuasive writing has the goal of persuading, of actually obtaining the reader to be on my side, obtaining that judge to rule in my favor. Okay, so I may expose all, and I should expose all the facts of the case, but I will certainly highlight those that favor my position, and I will minimize those that don't. So what should I do to effectively write a persuasive draft? And here's one quote that I like from Brian Garner again, my great idol and the idol of all of the legal English teachers around the world. Make every page a winner. Okay, that's a great quote. Develop a theory of a case. Consider your audience. Who is reading this? This will be read by the jury, or this will be read by the judge, or this will be read by the court clerk. Keep your theory and counter your opponent's theories. Tell a compelling story. Tell a story. Do not just inform. Tell a story. We remember a story, okay? Have that story flow, okay? Prioritize the strong points in your argument. Make rules work for your client. Distinguish favorable and unfavorable precedents. Quote correctly and use language in your favor. Okay, and let's talk about contracts and transactional writing. Contracts have a different use of English, and modal verbs are very important for contracts. It's not the same thing to say the seller may deliver the goods than to say the seller can deliver the goods than to say the seller must deliver the goods. The problem is the seller shall deliver the goods. So try to avoid shall and use will to establish future consequences, and use must if you have to impose an outright obligation. Use plain English. You can use plain English in drafting contracts. Sometimes we need to use legalese and certain specific words, but try to define, and definitions will help your contract work better. Use short sentences. Try to use titles, subtitles, and indexes. Use always the active voice. Beware of modifiers that actually may create confusion. Modifiers are when I said red apples and pears, and we don't know whether the pears are red or not. If we are writing a contract, it isn't incorrect to repeat. If you need to repeat red apples and red pears. Because actually interpretation in contracts under common law is much stricter than under civil law. So you're not writing a novel. So if you have to repeat a term, then do so, if for the sake of clarity. Avoid nominalizations. We already talked about that. Define terms and use vertical formatting, sections, subsections, okay? Try not to use the herein above, herein below. Try to mention, as mentioned in section 5.3. Let's talk about regulatory drafting. When you're drafting a regulation, keep in mind that you have to have a structure. And the most important thing is to keep in mind the purpose. First, what kind of regulation is it? And second, what is that regulation for? State whom it affects and who should comply with it. Organize your information. Order your information logically and make your headings. Organize that information that they are clear to the readers. and keep your paragraphs under control. Try to avoid double negatives. The following cases will be not included in the exceptions. So if they are not included in the exemptions, then they are prohibited. Try to be straightforward, whether you're drafting a statute or just a very a simple guide for internal compliance. Please bear in mind that, and this is a problem that we face nowadays with regulatory documents, that they are so long that many times rules are not complied, because actually the people that have to comply with those rules don't understand them. And actually the problem comes from the writer, from the drafter. Every good draft, whatever your writing is, whether it's a memo, objective writing, whether it's a claim, persuasive writing, emotional brief, whether it's a contract, transactional writing, or if it's a regulatory writing, your draft, your piece should start with a plan, because every good draft starts with a plan. And what's your biggest challenge as a writer? It's to figure out from the massive possibilities that you have exactly what are the points that you want to put through to your recipient, and then enunciate them in a coherent form with proper reasoning and support. And of course, the quote is from Brian Gardner. So I want to thank all of you for your patience through these almost 80 minutes of lecture, and we have 10 minutes for questions.
Thank you very much, Consuelo, for everything that you managed to say in this hour and 10 minutes. So now it's time for your questions. We've had some in the chat. Let me tell you what they've been asking. There's a comment by Juan Cruz Bustos. He says, I'm a lawyer working for an immigration law firm in the United States. I want to improve my English skills, not only in writing, but also in speaking and expanding my vocabulary to express better myself. Which course best suits my needs? I told him in writing about the practical and intensive course in legal English and the plain English skills for lawyers. So you might want to tell him about your course a little more. I don't know what you think.
I think the practical legal English is a course that's, well, it's 4 months, it's 18 classes now, and it's comprehensive, so it's more complete, it's general and complete. So I would think that that course would be the first and foremost to, it's a good kickoff. Now, then, the plain English course by Joanna Richardson is great. It will help you a lot with writing skills, but it doesn't address the different areas of the law. It's more, Joanna's not a lawyer, so it is more about writing in general and plain English, not plain legal English. Now, I think that the practical legal English is the good course to start, and then I would follow both by the plain English course by Joanna, and maybe one course that would be more catering to your particular needs. And we have a great one on criminal law, and there are many other courses to go that will come out shortly, and maybe the course in the workshop and contracts can help you also. We had several students last year that were working in immigration in both in the practical legal English and in the plain English course, and also in the contract workshop. So I think that the three courses are great, and they were much useful to students that were in your exact same position. But I would follow that order: first practical legal English, then plain legal English, and then one that's more focused on your special needs.
I agree. Thank you very much, Consuelo. One of the comments we had when you were discussing the vocabulary in connection with contracts was by Martin Lopez, and he said, sometimes we do celebrate the contract.
Well, it's not a
Celebrating
common
in the sense of being happy about the contract.
Yes, and we have the and this leads me to talk about closing, and sometimes we have general actually general discussions about what's the meaning of closing, because sometimes we have several closings, and remember the period between the first closing and the second closing is called the sunset period. Now sometimes we have operations with several closings. Now when we say we close a deal, we generally have, you know, a celebration, and we toast and everything, yes, but we don't write, we don't draft se celebra este acuerdo, la celebración del acuerdo. We don't celebrate contracts, okay? So it's true, we do celebrate when we end a negotiation.
Okay, do we have any other questions? We have a couple of minutes before we close, and well, we still are receiving a lot of thank you notes for you.
Yes,
Consuelo,
a lot of familiar names.
Yeah, right.
Past students, thank you. Yes.
Many
yes.
repeat students who keep coming for your legal English tips and tricks. So I don't know if you want to add something, Consuelo. We may have a couple
no,
of minutes
for me, it's a treat. We are 5 minutes ahead schedule, which is actually a great, a great goal for me. I generally try. I generally step over time, so I'm really happy about that. But for me, again, it is. I love master classes because I think this is a way of paying forward, and this is a way of actually reaching a larger audience. And I hope that these small and quick and brief guidelines that I just gave you are useful. Try to put them into practice. Try to have a short plan before drafting, and try to think of your reader and your recipient. So I would say, first, have a plan. Second, what's my message? Third, is my reader going to understand my message? And I think that these general guidelines are applicable to any type of drafting and in any language as well. So thank you all for bearing with me for this hour and a half.
Thank you very much, Consuelo. And I think this was a great masterclass, and I'm sure many of you believe the same because you've been here with us for 1 hour and a half, and the number we had was excellent. So thank you all very much for being here, and keep in touch.
Okay, excellent. And you can reach Juan Ignacio for any additional questions. Thank you very much and hope to see you around. Bye-bye. Stay
Thank
safe.
you. Bye-bye.